Hi, my name is Lisa Wiznitzer, and I'm here with my colleague Nerissa Coyle McGinn, and we're going to be chatting today about the right of publicity and generative AI. We'll cover everything from protecting publicity rights to how to leverage AI without infringement. So let's start a little bit by giving an example of the reason why we're here today and why everyone is so interested in this topic of generative AI and the right of publicity.
Second youngest son. He's suggesting it came out of nowhere. What we subsequently learned is it may have come from the former president or his legal team acting in bad faith. This is a deepfake example of what is possible with powerful computer and editing. It took around 72 hours to create this example from scratch using extremely powerful GPU. It could be improved with more computing time, but 90% of people cannot tell the difference.
So pretty scary. So that was an example of Anderson Cooper, and you can see how closely the original and deepfake are to one another, and yet how the vocals are entirely different. So how does AI work and what is the history behind AI? And we'll go over this quickly because I know you've probably been to a lot of AI CLEs so far, and this has been out there for a while. So artificial intelligence, as I'm sure you know, is not new. It actually started in the 1940s, 1950s. One of the pioneers of machine learning, Alan Turing, you might have heard of the Imitation Game movie, which is about the creation of code-breaking machine that could decipher Enigma codes. So take us all the way back to the 1940s, 1950s. What is machine learning? So machine learning is a type of artificial intelligence that allows computers to become more accurate at predicting outcomes without explicitly being told to do so. It's a much more basic type of artificial intelligence, and what's important for our knowledge is that it requires a lot of human input. So for example, in machine learning, you'll feed the computer pictures of, let's say, a cat. Then the human would identify the features used to identify what a cat is: pointy ears, a whiskers, a tail, maybe the size of the cat, the color. And then based upon those features that were identified by a human, the computer would learn how to be able to, in the future, properly identify cats. But we've come a long way from identifying cats. And we have a lot of examples of deep learning algorithms in everyday life. So combined with sort of the pioneering efforts of natural language processing, we were able to reach a new level of modern AI applications that included human-computer interaction as well as language understanding. Taking that one step further, AI began to perform a lot of complex cognitive tasks that are typically associated with human intelligence. So instead of looking at a map and trying to figure out where we were going, we had Google Maps, for example. We had facial recognition and detection that used virtual filters in our faces or Face ID to unlock our phones, and a lot of other types of examples as well. But we're not here today to talk about those examples. We're here today to talk about sort of the evolution from those examples, which is generative AI. And that primarily entered the field in 2020 with ChatGPT. So the difference between those examples and generative AI is that generative AI refers to a type of artificial intelligence technology that's designed to generate new content, such as images, text, music, or other forms of data based on patterns and examples that it's learned from, and this is key, a training data set. So unlike traditional AI models, deep learning, machine learning, that are focused on recognizing patterns or making predictions on existing data, generative AI models are capable of creating entirely new content that resembles the input data, but is not an exact replication. So how does it work? Briefly, first, you have to train the generative AI model. And the core concept behind that is that there's algorithms that learn sort of the underlying patterns and structures of the data that is used during the training process. These models can then generate new samples that exhibit similar characteristics to the training data. And to do this, you have to feed the system or the model an incredible amount of data. And this data, from a terminology standpoint, is referred to often as input data or training data. And let's just say a lot of data is needed. So OpenAI fed GPT-3, for example, with over 570 gigabytes of text data from the internet, which is a lot. To put it into perspective, 570 gigabytes of data is the equivalent of over 1.3 million books, or more than 3 times the amount of text contained in the entire Library of Congress. So it's a lot. The next step that comes from that is once the AI model is trained, that's when someone like you or I could use the model. So that's when we get to go in and use what we often refer to as a prompt. This is us telling the AI model what we want. I want a commercial script for XYZ product. Please talk about, the products being better than competitors and that people like it more. I also want the commercial to have a joke and a curse word in it. Then the AI model would create the output or the commercial script. So that was pretty fast, but at least we all now have sort of a basis of terminology of what we're talking about when we're chatting about generative AI. When it comes to the right of publicity, the application of generative AI is relevant in a lot of examples that we're seeing today. So we've seen 11 labs with AI voice cloning. We've seen deep fakes from synesthesia and other partners in the industry in video, even OpenAI with a text to video model. We've already also seen a lot of examples that have gone viral. So here's an example from EDM artist David Guetta.
This is the future rave sound. I'm getting lost in an underground. This is the future rave sound. I'm getting lost in an underground.
Eminem, bro. There's something that I made as a joke, and it works so good, I could not believe it. I discovered those websites that are about AI. Basically, you can write lyrics in the style of any artist you like. So I typed, write a verse in the style of Eminem about future rave. And I went to another AI website that can recreate the voice. I put the text in that, and I played the record, and people went nuts.
Pretty scary for musicians. We also saw an artificial intelligence collaboration between Drake and The Weeknd go viral. It generated, over 600,000 streams on Spotify and very quickly 15 million views on TikTok. There was a ghostwriter behind the track, and the track was actually initially popped up on YouTube and a bunch of streaming services, but then, there were takedown notices that were sent. It was taken down. And a representative for the ghostwriter confirmed to the Times that this song that was created, Heart on My Sleeve, was submitted for Best Rap Song and Song of the Year awards that, are given to songwriters as opposed to performers. So interesting issue that is already coming up in the music space. We've also seen a lot of movie and television stars being used in other ways, so primarily for endorsements. Tom Cruise even so much as came out to say there's a video out there promoting some dental plan with an AI version of me, and I had nothing to do about it. Likewise, Gayle King did the same thing, saying that there were a lot of messages on Instagram that were overflowing, but she never actually did this endorsement video. We're also seeing it in the political space with robocalls. So thousands of New Hampshire residents received robocalls explicitly discouraging them from voting in the primary election. These calls falsely stated that their votes were needed to be saved for use in November's general election, and that casting a ballot in the current election would be ineffectual. In actuality, voters are able and encouraged to vote in both the primary and general election. We know that Biden would not have made that call. But to the casual listener, it really sounded as if President Biden was directly instructing them not to vote. Up to 25,000 of these calls were made. And in response to this, actually, the FCC moved quickly to declare that AI-generated voice calls meet the TCPA's definition of artificial. And as recently as this past Friday, the FCC chairwoman vowed to take a very strong position on enforcing TCPA protections against AI-generated robocalls, and in particular that they're considering new AI election-related disclosure regulations specifically relating to robocalls. They ended up taking action against Democratic consultant Stephen Kramer, as well as Lingo Telecom, who were behind this robocall. We're also seeing it in a different space, very different than political robocalls, but there's deepfake porn videos using, everyday high school girls, as well as celebrities are, on the rise on the internet. And we could go on and on and on about examples that we're seeing in the generative AI and right of publicity space. But I'm sure you already know about a bunch, otherwise you wouldn't be here. So let's talk a little bit about the current state of right of publicity. Can the current right of publicity law stop any of the examples that we just talked about? Not really. More precisely, sometimes, in a few states, but not always, and usually not in what might be considered the most egregious situations. Why? So in a nutshell, one could probably stop some AI-generated uses of identity in advertising in a lot of states, but maybe not media advertising or political advertising, and we'll talk about that a little bit. So what is the right of publicity? Arguably, I would say it's one of the most intuitive of intellectual property rights. If copyright and patent law protect what you create and trademark law protects what you symbolize, the right of publicity protects who you are. It prohibits the unauthorized commercial exploitation of one's name and likeness, and sometimes voice or other indicia of one's personality. Importantly, it's a creature of state law, and it varies a lot from state to state. About 38 states recognize it for the living, around 20 recognize it for the dead, and the various states have different terms or no terms of posthumous duration. So depending on the state, it might last for your lifetime or for 20 or 30, 40, 50, 70, 100 years after death. Or if the right is commercially exploited after your death, potentially indefinitely. Because of the state law nature of the right of publicity, what is legal in one state could be illegal in another. State laws also vary a lot on who is protected. They vary as to whether all persons are protected or only those with what they often refer to as commercially valuable NIL is protected under the law. So celebrities, for instance. Some states, though, apply to all people. So take a look at this video. Russell Christoph, the charming gentleman pictured here, posed for a Nestle photo shoot in 1986. He was to be featured on the packaging for a brick of instant coffee to be sold on the Canadian market. He was paid around $250, and he was told that he'd receive $2,000 if the company actually used his image on the Canadian coffee brick. Well, they did use his image in 1986, but they also found the file 11 years later and used it, although slightly altered, on their redesigned packaging for their Taster's Choice coffee that was sold in the United States, Mexico, South Korea, Japan, Israel, and Kuwait. Mr. Kristoff happened to see his face on a jar of coffee in 2002, and a legal dispute ensued with Nestle. Nestle turned down his offer to sell her for $8.5 million. And then in LA, court ordered Nestle ultimately to pay him $15.6 million for using his likeness without permission, and profiting from it. Procedurally, the decision was ultimately reversed, but the lesson to take away from this is really, again, beware of unauthorized use, even for people who we don't consider celebrities. Some states will only protect people with commercially protectable or commercially valuable NIL. Here's an instance where the Ninth Circuit, for example, has held that under California choice of law, you look to determine the domicile of a deceased person to determine whether or not a right of publicity exists. New York is only life, and so it really depends where you are. There was a suit between Princess Diana's estate and the Franklin Mint on an appeal from the district court that ultimately brought a suit based on Franklin Mint's promotion and sale of jewelry, plates, and dolls bearing the name and likeness of the late Princess Diana, claiming a violation of her right of publicity and false endorsement. The Ninth Circuit ultimately decided against the fund's right of publicity claim because of the law of Great Britain. Diana's domicile at the time of her death does not recognize a post-mortem right of publicity. So what actually is protected? How recognizable does someone need to be? A leading case here with respect to whether a persona can be identified by objects rather than the actual person, or objects associated closely with the actual person. In this case, Lothar Maschenbacher claimed that his race car was distinctive enough, always appearing in red with white pinstripes and the number 11 in a white oval. Reynolds Tobacco used a touched up photograph of him in a television commercial. And although he was in the car, his facial features, as you can see here, are not identifiable. They also changed the number from 11 to 71 and added the word Winston to the spoiler. A balloon message appeared above the car with words, "Did you know that Winston tastes good like a cigarette should?" The Ninth Circuit here ended up reversing a defense summary judgment and held that the question as to whether Maschenbacher was identifiable based upon the photograph here was a question for the jury. In this case, with the naked eye, you can determine that he's actually in the picture. But they actually said that this went to a jury. They, I believe, ended up settling here. What about drawings? So in this case, Donald Newcombe was an all-star pitcher for the Brooklyn Dodgers. His career was cut short, however, due to a personal battle with alcohol. But at the time of the dispute, he was the director of community relations with the Los Angeles Dodgers, and he was active in fighting alcohol abuse. Coors Milk published an advertisement that featured a drawing of an old-time baseball game next to a picture of a glass of beer. The drawing did not depict an actual team or an actual stadium, but Newcombe, his family, his friends, and his former teammates recognized him from his playing days, since he had a very weird pitching stance at the time. Coors denied that the drawing was his likeness, but admitted that the advertisement was actually based on a newspaper photograph of him from the 1949 World Series. His number was 36. The drawing has the number 35. He ended up suing for a variety of causes of action. And on appeal, again, the Ninth Circuit had held that this was a triable issue of fact with respect to whether he was, actually identifiable in the advertisement. They stated that the facial features in the drawing aren't clear, but noted again that he had this weird wind-up stance and that the drawing was virtually identical to the photograph, and the pitcher's skin in the drawing was moderately dark like Newcomb. So you can see sort of how we're evolving and how close you can and can't be, and how it ultimately becomes an issue of fact. This is one of the first look-alike cases. In this case, the court held that anyone that looked at the picture would know that this is not Woody Allen, but Allen, in this case, won on a case of false endorsement. We saw a similar case with Bette Midler, where only her actual voice was protected under statute, but allowed a claim under, a common law theory here. So we're evolving in the right of publicity. This one, and we're almost done with examples here. This is an interesting one. So Samsung produced a television commercial advertising its VCRs, and it showed a robot wearing a dress with other similarities to Vanna White standing beside a Wheel of Fortune game board. Even on their internal documents, Samsung called this one the Vanna White ad. So White ended up suing Samsung for violations of right of publicity, and the Ninth Circuit ended up reversing a district court, but ultimately found that White had a cause of action based on the value of her image and that Samsung had appropriated this image. So what you can see here is that, you're not only talking about actual people, you're not only talking about objects, you're not only talking about voice, you're also talking about potentially dolls or robots that look like other people. And in one of the most recent cases, in September 2019, Ariana Grande filed suit against Forever 21, again for right of publicity violations, claiming that they violated her right of publicity when they posted pictures, videos, and lyrics without her permission, and used actually a look-alike model that was dressed in similar clothes to those that were worn in Ariana Grande's 7 Rings video. You can see in the hair, very similar, even in, the pink puffballs on top of her head. There were a number of posts here as well. Ultimately, they agreed to remove the pictures from social media, but they didn't remove them very quickly, and so ultimately Grande asked for up to $10 million in damages. Courts ultimately look to the totality of the image. So it's not just the individual attributes of a celebrity used in isolation, but it was all of them used together here that really could lead people to believe that this was actually Ariana Grande, and that her right of publicity had been violated. So that's a lot of what actually is protected and a lot of examples of what's protected under the right of publicity. But what about what's not protected? What about fair use? What about the First Amendment, for example? Here's an example that goes into that First Amendment conversation. In connection with Michael Jordan's induction into the Hall of Fame, Sports Illustrated published a special tribute issue to Michael Jordan. Jordan ultimately claimed in a pair of lawsuits in 2010 that Dominick's and Jewel had used his likeness without permission. An amended version of the complaint, alleges that they violated his Right of Publicity Act. And in February 2012, the district court in the Jewel case found that the ad was actually non-commercial, saying that it didn't sell any specific product, and ultimately granted their summary judgment motion. However, the Seventh Circuit disagreed, reviving the suit 2 years later because the ad was a form of image advertising aimed at promoting goodwill. So while speech may be commercial ultimately the takeaway from this is that speech may be commercial for First Amendment purposes, even if it's not specifically expressly promoting a particular brand or product. Jordan subsequently settled both of these cases, but it's a really great example of the discussion of the First Amendment protection in this. In another case, and this is a more recent case, you can see that the ground for debate between the First Amendment and the right of publicity even goes into art. So you can see there's multiple images of Tiger Woods here, making lots of different poses. And ultimately, the Ohio federal court in this case rejected Tiger Woods' argument that the print was unworthy of First Amendment protection. And the court found that the print sought to convey a message and that the message was a unique expression of an idea rather than the mere copying of an image. And so this one was ultimately protected by the First Amendment. So the takeaway here that the court says specifically in this case is that when an artist adds significant expressions to an image, then the artist enjoys First Amendment protection for his work. But what makes something transformative versus not transformative? In these cases, you can see that these, are certainly somewhat artistic, but similar to the Ariana Grande example, they're not transformative enough. And so that's what happened in the EA case here with the NCAA athletes, and that's also what happened in the No Doubt case on your left-hand side here. All right, we're gonna now dive into sort of how all of that right of publicity background and AI background, how do those actually merge into this generative AI that we're seeing today, and what do we take away from it? But before we do that, and before I pass it off to Nerissa, here is your CLE code, RPG 930. We'll also put that in the chat for you. All right, I'm going to pass it on to Nerissa to talk about, the application of the current right of publicity laws to AI.
Great. Thanks so much, Lisa. So now that you know everything you need to know about right of publicity laws in the US that we have right now, we are going to try to apply those to AI. And this has been done a couple of times, and we'll kind of see where we are. If we can go to the next slide. As Lisa mentioned, several celebrities have had their images copied by AI and then used in different types of commercials. Tom Hanks, she mentioned the dental plan. She mentioned Gayle King. Her image was used for a weight loss product. And this is actually a video that I think we're probably going to skip. Of Taylor Swift in a fake advertisement for Le Creuset. Most of these celebrities have not brought right of publicity claims. Instead, what they have decided to do is to go on social media and say, hey, tell their fans, hey, this isn't real. That really is not me. But these are really the types of cases that are tailor-made for all the laws that Lisa was just talking about. There's a celebrity involved. There's a commercial use. So these should be easy claims for the celebrities to win if they wanted to bring these cases. I think that they just don't do it just because it's pretty difficult. It's going to take a long time. They can get something done a lot quicker on social media, and the people that are making these deep fakes probably don't have very deep pockets, so they're not going to make a ton of money off of it. If we go to the next slide, the cases that might be a little bit harder that we're seeing are these deep fakes of influencers. The first picture is a picture of an influencer, Jordan Howlett. He's a 26-year-old influencer, and he has deals with Domino's Pizza, Google, and Wingstop. And he has over 20 million followers. one day he received a social media message asking him why he was promoting a cure for blindness, and he checked it out, and it was his voice that was in the voiceover, but it wasn't his. His image was not being used in the advertisements. And so they used a lot of different false claims in their saying that if you did this 7-minute ritual, you could get your vision back, things like that. So this was something that was upsetting to him. The second video is a influencer. She's a 20-something gal. That's how she describes herself. She's and she has 150,000 followers on TikTok. And she found a deep fake of herself selling erectile dysfunction drugs. These cases might be a little bit harder because these people aren't quite as famous as someone like Tom Hanks or Taylor Swift. But again, our right of publicity laws today really work for these cases because you have people that are selling goods with their personalities. They are somewhat well known, and their images are being used in commercials. So if we go to the next slide, now we're starting to step out of the right of publicity comfort zone. This case is Young versus Neocortex. It's one of the first right of publicity cases involving AI. Neocortex has an app, it's called Reface, and it allows you to, swap out your face with a famous person's face. So you can take a picture of yourself, and then I can look like, I don't know, Jennifer Aniston if I want to. So a celebrity, Kylan Young, sued Neocortex because, and he actually brought a putative class action against Neocortex. If you don't know who Kylan Young is, I did not know, but he's a reality TV star, and he was on Big Brother. It alleged that Neocortex violated California's right of publicity statute by using Young's name, his likeness, and his voice for purposes of advertising or selling or soliciting products or services. Neocortex filed a motion to dismiss, alleging 3 things. The first thing was that they alleged that Young's right of publicity was preempted by the Copyright Act. The second is that Neocortex artistic work was so transformative that it was barred by the First Amendment. And then the third is really just that Young has not shown that Neocortex violated its right of publicity. So we're just going to look at all 3 of these. First one, for the copyright preemption, the court rejected that argument. The Copyright Act does provide that state laws that are equivalent to copyright are preempted, but the court found that Young's right of publicity really is different than a copyright, and so they rejected that argument. So we know that one is kind of gone. The court also rejected the argument that the artistic work was so transformative that it is barred by the First Amendment. The court said that in this case, that Neocortex did not transform Young's image. Instead, it just took his image and then put what looked exactly like his face onto someone else's face. So there really was no transformation of Young's right of publicity or his face. They compared this case to a case with to the Hilton versus Hallmark case. This is another right of publicity case where Hallmark was taking a cartoon of Paris Hilton and putting it on their cards. And they said that this is different than a cartoon-like image, and it's not as transformative since it's his actual face that is being put on into these new images. Now, finally, so that one also is rejected. So the big one is the right of publicity, right? That's the one that we have a lot of questions about. And to prove under California law that there's a right of publicity, or to prove a right of publicity action, you have to show that the defendant knowingly used the plaintiff's identity. And Neocortex argued that that Young did not show that neocortex knowingly used Young's right of publicity, or that the likeness of his face. They said that the AI went out there and just scrubbed the internet and pulled all these different images, and they had no idea what images were being used. The court rejected this argument. And they concluded that showing some type of constructive knowledge was going to be enough, at least for the motion to dismiss stage. So this is still ongoing. We still don't know if this is going to be a violation of the California Right of Publicity Act. The one thing that I find kind of interesting is that neocortex never really argued that this was not a commercial use. It would have to be a commercial use under California's right of publicity law, and they didn't really bring that up. They kind of gave on that. I think they probably would have ended up losing on that, but I still think it's interesting they didn't try to argue it. So if we go to the next slide, now that we've kind of looked at a couple of examples of, the AI law being applied, or, right of publicity law being applied to AI, we're going to look at what some of the problems are with taking our current right of publicity laws and trying to apply it to AI. And I think we've started to kind of see that with neocortex, but we're going to kind of delve into that a little bit more. The first problem that we have is that the right of publicity law can only apply to commercial uses, either because of how the state law is written or because of the First Amendment. And based on these old cases, what is a commercial use? We know that it includes a commercial, possibly in a video game. What about a piece of art? And what exactly is art? And based on the current case law, we also know that the person's image in an output may be an issue, but there are a lot of different uses that we need to look at. So we shouldn't really only be looking at commercial cases, and we shouldn't only be looking at the output of the AI. We need to look at all types of cases, and we need to look at the entire AI process to see whether or not the right of publicity is going to apply. So let's go to the next slide. Let's start at the beginning, of the AI process. Let's start with the training materials that Lisa told you about. And there are a lot of ways, a lot of different materials that can be used for training materials. It can be books, it can be pieces of art, and it can be someone's image. If we go to the next slide, the use of likenesses and the right of publicity in training materials has already been challenged in Anderson versus Stability. And many of you might know this case already, but you probably know it more as a copyright case. The main claims in this case is that Stability AI trained its AI on the plaintiff's artwork. And they were arguing that this was a violation of the copyrights in their art. But stuck in this case is also a right of publicity claim. The plaintiffs however, are really having a hard time making this one stick. At first, they were arguing that the defendants were violating their right of publicity and their artistic identities in their arts. So they supported this claim by saying that Stability AI, like when you're using Stability AI, you can ask for artwork that is in the style of the plaintiff's name. So this is kind of like the Newcomb case, the pitcher case that Lisa was talking about, where the pitcher had a right of publicity in the style of his pitching. And they're kind of saying that they have a style, they have a right of publicity in their artistic style. But according to the court, the plaintiffs said that the plaintiffs have kind of retreated from this argument Instead, they are now arguing that Stability AI misused their names by associating them with the AI image output for commercial purposes. They went on to argue that Stability AI was using the plaintiffs' names to promote their products, which is a much more traditional right of publicity claim. The court, though, excuse me, ended up dismissing the right of publicity claims because the plaintiffs never alleged that their names were actually used to advertise the products. So it feels like there's a right of publicity claim here, but they're just not able to fulfill the elements of the right of publicity claim. So that's a problem. Let's go to the next slide. Well, we've been looking at some of the outputs of the AI. Before you get to the output, you have the prompts. And what if you use someone's name in a prompt? We know that you can do that. Like you can say, I want artwork that is in the style of. So let's look at an example. I love this example because I love Ryan Reynolds. And so we're gonna show you this video and see what ends up happening.
Hey, it's Ryan Reynolds, owner of Mint Mobile. We're always looking for ways to save you money. So this year, we're kicking things off with an ad that I created using ChatGPT, the AI technology. This is what I asked it to write. I said, write a commercial for Mint Mobile in the voice of Ryan Reynolds. Use a joke, a curse word, and let people know that Mint's holiday promo is still going, even after the big wireless companies have ended theirs. This is what it wrote. Hey, it's Ryan Reynolds here. First of all, let me just say Mint Mobile is the shit. But here's the thing. All the big wireless companies out there are ending their holiday promos, but not Mint Mobile. We're keeping the party going because we're just that damn good. Give Mint Mobile a try. And hey, as an added bonus, if you sign up now, you'll get to hear my voice every time you call customer service. Just kidding, that's not really a thing. And stay classy, everyone. That is mildly terrifying, but compelling.
So, Ryan Reynolds saying, hey, I want a commercial that sounds like Ryan Reynolds is not a big deal because that he owns his own right of publicity. But it could be a problem if a brand is saying, hey, I want a commercial in a famous person's voice. If they're doing that and it's, Ryan Reynolds' voice, maybe his voice isn't unique enough or his style isn't unique enough. But let's say they do something like Billy Crystal and they use a catchphrase like, you look marvelous, or Bruce Willis and they use yippee-ki-yay. Any of those is going to start to be a problem. This made me think of an old case. This is Bette Midler versus Ford Motor Company. This was a case where an agency was, they pitched an ad to Ford Motor Company, and they said in the ad they were going to have Bette Midler sing one of her famous songs in the background of the ad. Then the first problem that came up is that then they go to Bette Midler and they say, hey, do you want to sing this song for the commercial? And Bette Midler's like, yeah, I really don't want to do that. So they don't get Bette Midler. Then their second problem is that they decide, hey, we're going to get Bette Midler's backup singer. And when we ask the backup singer to sing the song, we're going to tell her to sing it like Bette Midler. They ended up losing this case, and part of the reason that they lost the case was all of that information was discoverable, right? They knew that they wanted Bette Midler for the case. They asked someone to sound like Bette Midler. They might not have lost if they hadn't had all that information discovered. So when you're creating this type of content, you have to realize that your prompts could be discovered. And if those are discoverable, that could be used against you if there ever is an issue. So now let's go to the next slide. We've looked at the training materials. We looked at the prompts. Now let's look at the output. And what happens when that output is not a commercial? So if we go to the next slide really quickly, we can play this video really quickly, just because I think it's It is pretty interesting. This is a video that was created by a pair of podcasters, and they admittedly fed thousands of hours of George Carlin's stand-up into an AI, and this is what they created.
Yes, there's one line of work that is most threatened by AI, one job that is most likely to be completely erased because of artificial intelligence. Stand-up comedy. I know what all the stand-up comics across the globe are saying right now. I'm an artist, and my art form is too creative, too nuanced, too subtle to be replicated by a machine. No computer program can tell a fart joke as good as me. Well, let's see.
Okay, so the estate of George Carlin actually sued these podcasters, and they alleged that the use of Carlin's work to create a new AI stand-up comedy routine was a violation of his right of publicity. This case ended up settling, so we don't know how it would have, what would have happened in this case if this would have been considered a commercial use. You also have to realize this was brought under the California right of publicity statute, which is a really strong right of publicity statute for obvious reasons. So you don't know what's, we don't know what would end up happening, but this is the type of thing that could potentially be a problem. And speaking of, California and Hollywood, one of our favorite things is SAG-AFTRA, and looking at SAG-AFTRA contracts, there are regulations now that we are, guidelines that we have to follow on AI. They actually split AI into 4 different categories. Some have more guidelines than others. The highest protection is really when you're creating the AI from, stuff when someone's in their employment and then creating new scenes. And then there's less protections for someone that is in the background. There also are some guidelines for digital alterations. All of these are on the SAG-AFTRA website, so that's somewhere to look at. If we go to the next slide, not only do we have creative content, but we have political content. So this is actually a political ad that was created solely from AI, if we want to watch this really quickly.
This just in, we can now call the 2024 presidential race for Joe Biden.
My fellow Americans.
This morning, an emboldened China invades Taiwan. Financial markets are in free fall as 500 regional banks have shuttered their doors.
Border agents were overrun by a surge of 80,000 illegals yesterday evening.
Officials closed the city of San Francisco this morning, citing the escalating crime and fentanyl crisis.
Who's in charge here? It feels like the train is coming off the tracks.
So all of those images were created by AI. And, this is obviously commercial, or not commercial speech, it's political speech. So it's given a lot more protection under the First Amendment. So where does this leave us? If we go to the next slide, it really leaves us looking for guidance from the government on what is going to happen here. So we'll look at the federal laws first. And is there going to be any type of federal law? I mean, we are trying our best and we're hoping to get one, but I don't think we're going to get one for this election. It's pretty far along at this point. Amy Klobuchar has introduced several bills. She introduced the Real Political Ads Act. This would require some type of disclaimer in the political ads if there is AI that is being used in images or video. That already sounds outdated given what Lisa was talking about with the robocalls. Then Klobuchar also has introduced another act called the Protect Elections from Deceptive AI Act. This would ban the use of AI to generate materially deceptive content. And then just to show she is the most persistent senator that we have, Amy Klobuchar also introduced an AI Transparency in Elections Act that is, again, trying to stop any type of anything that was substantially generated by AI from being used in all types of media. So it's kind of just broader than some of the other acts that she had. If we go to the next slide, the FCC, as Lisa has said, has also banned deep fakes in robocalls. And then if we go to the one more slide, there are several states that have passed. These are only the states that have passed some type of AI legislation related to election advertisements. Sometimes it makes it a crime. Sometimes it just requires a disclosure. So you have to look at each state individually, just like the right of publicity laws. The other thing, if you go to the next slide, that we're looking at is that some of the platforms are requiring disclosure of AI. Really, it's if like anything is materially altered or created, then it needs some type of disclosure. This is true on Google and on Meta. There are exceptions for both of these if it's just like a minimal change to the advertisement. So if we go to the next slide, let's talk about another problem that we have is, does the right of publicity apply to non-celebrities? As Lisa told you, yes, in some states, no in others. Why is this an issue? Lisa did talk about these a little. According to an independent researcher, there are already, and this is actually a few months old, more than 143,000 deepfake videos were posted this year. That surpasses every other year combined. These videos can be incredibly damaging, especially deepfake porn videos. They can be considered a form of bullying or harassment or intimidation. We have the example of, teen girls having these deepfake videos, sexual videos sent out on social media. And many times, like these people feel as if the police really aren't doing anything about it. There might not be a criminal law that covers it. And if they do take some type of civil action, there's really that is just not going to be enough and is not going to work fast enough for them. There are some federal laws that have been proposed. Amy Klobuchar is here again. She has the Defiance Act that gives you a federal civil remedy for a digital forgery. And there are even some issues, even if you just possess the deep fake with the intent to potentially distribute it. The other interesting point about this is that it creates a 10-year statute of limitations that does not start until you turn 18. So it really kind of gives a chance for someone that is a teenager to bring an action if they want. If we go to the next slide, this is a list of all of the deep fake laws that have been passed on the state level. Again, these are enacted laws. These laws really there's a lot of differences between them. Some of them are civil, some of them are criminal, and some just relate to child porn. If we can go to the next slide. So what if the deep fake is not an impersonation? Maybe it isn't a right of publicity issue, but there are several issues that you need to be aware of. So let's look at this next video really quickly.
Come with me and you'll be in a world of pure imagination. Take a look and you'll see. There is no life I know to compare with your imagination. Living there, you'll be free if you truly wish to be.
So the interesting thing about this video is that AI is saying, or Dove is saying, we're never going to use AI. But how can you use AI if you're saying that you want to show real beauty? Because nothing in the AI is real, right? So they really can't be using AI. And this becomes even more of an issue if you have someone that's, selling a weight loss drug, or, selling a specific skin product that says that, you're not going to have lines. You really need to have disclosures to be able to show that they're, to say that this is not an image that is real. This is not a real person. This comes up if we go to the next slide, also with virtual influencers. This is something that we've had for a long time. This is little Michaela, and she's been a virtual influencer for many, many years. When you do use these types of virtual influencers, if we go to the next slide, you really have to disclose the fact that it is a virtual influencer. You need to be able to say that there is a material connection between that influencer and the brand. And if your influencer is created by the brand, that your influencer actually is the brand, that your influencer tried a product because it's not a real person, or that the influencer can't really give a review. All of those things need to be disclosed. This is also true if you're using, chatbots. These are some examples of chatbots that are being used on Meta. We have Tom Brady will talk to you about sports. Kendall Jenner will give you big sis advice about being style advice. If someone is not talking to an actual person, they're talking to an avatar, they're talking to a chatbot, you have to disclose that. So if we go to the next thing, at the next slide, what you really need to disclose in these is that you have to disclose that people aren't interacting with the chatbot. If it is some type of customer service, that there is a way to appeal some of the decisions that are being made by the chatbot. So now, really quickly, I want to go over what is the future of the right of publicity law. Next slide is, we do have some right of publicity laws that do address AI that have been around for a while. This is one from New York that was signed in 2020 and has to do with the posthumous right, images of someone. And we are getting, if we go to the next slide, some state right of publicity laws. The really famous one is Tennessee passed the Elvis Act that is going to protect voices. It also can go after the platforms themselves for the creation of the AI. Illinois just amended their right of publicity act to include digital images. California just last week amended their AI Act, their right of publicity act, and they also created an act related to contracts and the use of digital images of people, and that if certain conditions aren't met, those contracts are not enforceable. The interesting thing is that for decades, I think that since I've been practicing, if we go to the next slide, we have been looking for a federal right of publicity law. But now it looks like, potentially we could get one. We have Congress has issued a report saying that it might be needed now. The Copyright Office has issued a report saying that it might be needed now. If we go to the next slide, we are looking at the USPTO also maybe issuing a report related to this. And then finally, we do have a couple of laws that are out there. The interesting thing about these is this first one, it does apply to all people, and it does not only apply to commercial uses. There is another act, if we go to the next slide, again from Amy Klobuchar, and It does not apply to only celebrities. It's all people, and it is not limited to commercial use. This one also can hold platforms liable. So that's something to be aware of. So that is our really quick review of right of publicity. We're just a little bit over the hour. If you have any questions, please feel free to contact me or Lisa. I saw that there were a couple questions that came up during the presentation. If you would like to send those over, we're more than happy to get back to you and answer those. Thanks so much.